Hi, Sean.
I talked to you yesterday.
Good. You are fantastic.
Thank you.
Yes. A great host. Show radio. Listen to his show.
Absolutely, 95.5.
Hey, everybody, this is Lieutenant Governor Burt Jones. I just want to give a big thank you to my good friend Shelley Winters. Last night wouldn't have been possible without all of his help, night in and night out, speaking the truth about what this election was all about and about who was the best person for the job. So thank you, Shelley, and keep up the good work.
Let's just take, for example, Tony Fauci, right? All those people that you mentioned, including him, have denied that they have done anything wrong. They've denied any federal criminal activity whatsoever. So if Joe Biden were to go so far as to preemptively pardon an Anthony Fauci, for example, history will forever judge him as being someone who needed a pardon. In other words, he had done some particular federal crime for which he needed a pardon.
Ladies and gentlemen, it's the Shelley Winter Show, live, local, topical, and relevant, ladies and gentlemen. We're here Friday night. It's a chilly one, but it's going to be fine. My warm, velvety voice is going to keep you warm on your ride wherever you're going tonight. So it's me who will keep you warm, not your car heater, but my voice, my warm, sexy voice. Let's go to my good friend. We're starting to show off. I'm feeling good. I'm all dressed up. If you go to WSBRadio.com and click on Watch Live, I am looking really good. Like I'm looking at myself on this video and I'm like, damn, dude, you are a handsome man. Phil Holloway, how are you, my brother?
I'm doing great, Shelley. But, it occurs to me that all I've got to do to save on my, power bill is, for heating this month is to just replay the Shelley Winter Show all the time throughout my house and keep it warm. Huh?
Absolutely. That's all you need to do. And listen live, 7 to 9 p.m. So let's get right to it, Phil. Phil Holloway, WSB, Shelley Winter Show legal analyst, Phil Holloway. He's also got a great YouTube page that breaks down a lot of the big cases, and we'll tell you about that in a little bit. But, Phil, let's first start off with these Biden pardons, the preemptive ones, not the Hunter Biden one, but the preemptive ones. We played a clip of you on Fox News Channel this morning, and you broke it down. Talk to us about these preemptive pardons, and are they legal?
Well, they're legal. I mean, the Constitution gives the President of the United States plenary, that means basically unlimited, unchecked power to issue pardons or forgiveness or clemency for federal crimes, and it doesn't even require that someone be charged with a crime. Think about Richard Nixon, who's pardoned by President Ford after taking office, and Nixon, of course, was never charged with anything. So it's legal, and there's really nothing that it's not, no court can touch it. There's nothing anybody can do about it if they don't like it. Now, whether it's a good idea or not is obviously the big debate, and I got to be honest with you, I don't think that our founders would have envisioned the situation that we are potentially presented with now, where you've got the likes of Fauci and others who, they're considering doing these preemptive pardons for. The House subcommittee on the coronavirus just issued a report that reads like an indictment, essentially, of Fauci for all sorts of things. And, you could make the case that he's maybe lied to Congress, maybe committed other types of fraud as it pertains to statements that he made about, the vaccines and other types of the COVID sort of interventions. And so, the idea that you're going to just issue a pardon to him or any of the others on the way out the door kind of makes a mockery of the whole thing. But there's really no other fallout other than political fallout. And in this case, of course, you've got a president who's just going to go off into retirement. So the political fallout he'll miss it, but the Democrat Party will bear the brunt of it.
And we're on the phone with Shelley Winter Show legal analyst Phil Holloway talking about these pardons, the preemptive pardons. Let's skip ahead, and I agree with everything you said. I think that now let me ask you this. He's pardoned. Let's say Fauci's pardoned, right, by Joe Biden. Can Trump and his team and his administration, can they come in there and still do an investigation, and then at the end of the day tell the American people, hey, this is what we found. This guy was corrupt. He made money. He lied, all of this stuff. But, we can't do anything to him, but you need to know the truth. Can that still happen?
Yes, a pardon does not prevent a subsequent investigation. And look, some of these things, to the extent there may be crimes involved, they don't just stop with Fauci and some of the other names that are being floated around. And I don't need to be picking specifically on him. It's just that there's a number of others that were mentioned.
Adam Schiff, Liz Cheney.
Yeah. Yep. So, I mean, it's like this whole thing is like, well, we're gonna go ahead and insulate you because we think that our political opponent might target you. Isn't that richly ironic?
Right.
But so there's nothing to stop an investigation. And look, let's face it, the House report, the committee report, that's just maybe step one. There needs to be a lot more sort of accountability for the whole process that brought the world to its knees, and it's bigger than just Fauci.
Absolutely. Let's skip ahead to Daniel Penny, that case in New York. Yeah. News broke this afternoon, a couple hours ago, that the manslaughter charge has been dropped. Talk to us about that. You said, when I text that to you, you said it was a ploy. Explain, please.
Yeah. So it's one of these things where the jury is, so in New York, it works like this. He's charged with the top count, the manslaughter that involves, the recklessness, the reckless disregard for human life, and that. And if you read the jury instructions, and this is the way it works in New York, the jury was not supposed to proceed to deliberate on count 2, which is the lower type of case involving criminal negligence, Shelley, with only like a 4-year maximum. So that's what we call the lesser included offense.
Right.
The jury is not supposed to get to even consider that unless they have found him not guilty on the top count, count 1.
So if the top count is thrown out, then there is no lesser count. Is that what you're saying?
It should. That's what should have happened. That should be the case. But the ploy that Alvin Bragg and his office used was they said, look, Judge, we're going to go ahead and just dismiss count 1. And by the way, they did that over the objection of the defense, which was smart by the defense, because now that it's been dismissed over objection, they can never bring that one back. So at least it's a victory in that sense for the defense, because any future prosecution on that would be barred by the statute of limitations. So we're just left with this lesser charge now, and the jury's going to come back on Monday to begin deliberation on that. But it appears, my sense is that the jury is still going to be very much divided. I think this is not so much a legal semantics division as it is, these are people from New York, and a lot of them ride the subways, and they know how violent these cases can potentially be. And so, I think that's some of the division.
I think the division is simply what we're seeing in the country, not the division so much in the country, but what we're seeing when people go back and forth about this case. There are people who are like, hey, he stepped in, let him go home. And I think that's what you have members of the jury who are saying, hey, I'm not sure, and I don't care about the legal, like you said, semantics, but a guy did something and tried to help people. Unfortunately, someone passed away, but hey, he shouldn't have threatened anybody on the train in the first place. So let this guy go home. I think you're right about that. Phil, I want to ask you about Fani Willis. Fani Willis was ordered to turn over communications in the Trump case by Judge McBurney. Can you explain what's going on there?
Well, so there was an Open Records Act lawsuit filed by, Judicial Watch. And so Judicial Watch said, look, we're going to file this open records request. And by law, the state statute on open records says, look, if any state or government agency fails to turn this stuff over and they violate the provisions of this law, you can bring a lawsuit. And so that's what they did. Willis apparently ignored the lawsuit. She just didn't even answer it. She went into what's called default. So this was a default judgment. She did not even challenge the litigation. Whether and when she is going to comply with that is another matter. I think she might be setting it up for some kind of appeal, but the law is is not on her side. There was a recent opinion out of the Georgia appeals courts that said that district attorneys can, in fact, be sued, and they're subject to the open records law just like every other government entity. And so I don't know that she's going to have much of a leg to stand on, but in any event, Shelley, she didn't even file an answer or even oppose that lawsuit at all. So this was what we call a default judgment.
So here's my real question. Let's say she turns over these files. We know that Nathan Wade had conversations with the White House counsel. We know he had conversations with Jack Smith. If we know he did, he just doesn't. In his testimony to the congressional committee, he kept saying he doesn't remember what those conversations were about. If we have paperwork and we have a paper trail of detailing those conversations, can Fonnie Willis be in trouble?
Well, you got to remember. If she says there are no responsive records for us to produce, then what is? I don't know what the remedy is. I think if she says, look, I understand the judge has ordered me to turn the stuff over. We don't have any such records, and if that's the case, Judicial Watch might be stuck. Of course, you can get into what's called post-judgment discovery, including post-judgment interrogatories, things that must be answered under oath. But this is a potentially long, drawn-out litigation process. She's going to stonewall. She doesn't want to answer these things. She doesn't want to provide anything that she might have.
Gotcha.
And if you remember from some of the testimony by Wade and them up in Washington, D.C., there was a lot of I don't remember and maybe exactly. I don't have records and that kind of thing. Right. So I think the plan here is to stall and prevaricate and put it off for as long as possible. So that's why,
because I was wondering, I was surprised that it was McBurney who made her do this, but that's why he kind of did it, because it's a safe thing to do. Oh, yeah, provide the paperwork. Oh, you don't have it? Oh, well.
Yeah. I mean, McBurney didn't look. It was a default judgment. The judge really had no choice. It's not like we had a contested evidentiary hearing and he had to make some decisions after that. His decision was made for him by virtue of her defaulting in the case.
Understood. Phil Holloway, how can people follow you and how can people watch your great YouTube legal page?
Oh, thanks. So it's youtube.com at Inside the Law, where we take you inside the real justice system, not the one that you think we might have. And, of course, on X at Phil Holloway ESQ. I've been pretty active there, particularly with this Penny case and other things that are going on.
All right. Phil Holloway, Shelley Winter Show legal analyst. We appreciate you, Phil. Talk to you soon, brother.
You bet, brother. Take care. Stay warm.
Yeah, you too. We'll be right back.